So welcome everyone from H1B Founders. So we're back here again after I think 2 or 3 months. Again back with Raghavan from Serotte Law. So what we want to do this time is really go back to the basics of being a founder on an H1B. Some foundational questions. We want to address that, and then we will get straight into the slide questions some people have asked. And towards the end, we also have time to get to some interactive Q&A as time permits. So again, I'm Sid Saraswati, and I'm here in Boston. The reason I'm here and we are all together is about a year and a half ago, I wrote a blog post on LinkedIn about I sponsored my own H1B, which got shared multiple times. My viral with 200,000 views and a lot of DMs. People curious and wondering if that's even possible. Joined by Raghavan Nagarajan, who is the person responsible for actually filing my H1B. He was my attorney who made it possible. And given that how this topic, as I know, coming from Mumbai, immigrating here 15 years ago, how complex, confusing, let's say mixed with myth, fear, and all kinds of various ideas that we have in our heads about what we can do. We cannot do an H1B. That was the reason I wrote that article on LinkedIn. So I'm running my own business right now in Boston, Trial and Error Inc. I have a product called Renovate AI that helps people visualize interior and exterior renovations. So that's been going good. In fact, a fun fact, since the last call, we have now as a company sponsored another H1. Again, Serotte Law was helpful with that filing. So I think that is, I would say, one of the proudest moment, I would say, of starting a business is the fact that, we could sponsor a talent. And, it was a fresh grad from Mumbai. We had him with us as an intern for about 6 months. And, he went into open extension. We were now able to file another H1B from our own business. With that said, one mic over to you. You want to introduce yourself and
Thank you. Yes. Yeah, my name is Raghavan Nagarajan. I'm a partner at Serotte Law. We're an immigration law firm. So all we do is immigration for business, families, those kinds of things. As Sid mentioned, I connected with him a few years ago as he was on his green card journey, but also looking to, I guess, accelerate the process of being able to work for his own company. As we'll probably get into in the details, the paradigm, the landscape for H-1Bs has changed since that time. Some of you may expect that it's changed for the worse, but actually it's changed for the better. And so when we were working with Sid, we really kind of were constructing a way to ensure that we follow all the rules of the program and still enable him to work for a company that he had significant ownership interest in. And that was kind of a model, not his case in particular, but that structure of what we did there was a model that we used for many different people. Now, since January, the structures have changed slightly to make it easier. And so I think the last time we connected, we spoke about that a little bit. I think we're going to speak about that again today. But just to give you some information about myself, I've been a lawyer since 2008, so close to 20 years, I guess, but actually working in the space of immigration law for about 10 years. And yeah, our profile of clients is mostly businesses of various sizes, but tends towards smaller businesses and especially startups and startup founders. And then, of course, like I mentioned, we do some family-based work as well. So if you're on this journey and you happen to marry an American, that's another thing that probably accelerates your process and something that we work on. But yeah, so that's a little bit about me, and I guess maybe over to Sid.
yeah, next half an hour, please post your question in Slido. It's the best way. So if you can read something and address, some commonalities. Rog, when I was started with the big one, which is can H1B visa holders legally start their own company or invest in a startup?
Yes, in probably all of the different ways and guises and forms that a US citizen or a green card holder could. You can form your own business that you 100% own and start working on that business, develop a product if you're in the kind of software product space, or advise financial clients if you're a financial analyst or something like that. You can do whatever work that you could do for that business. You could also invest in somebody else's business, and you could do all of those things that you could do as a permanent resident or a green card, or a citizen, but there's some extra steps to take, right? You have to follow the process of obtaining the specific work authorization through the H-1B program, which is going to take longer than if you were a citizen, because then you could just start immediately. But ultimately, yes.
Now, if a startup fails, what are the risks somebody who started their company they have to handle? Not able to pay back loan to the bank or an investor. So what happens to the immigration status if the startup is acquired or it's shut down?
So, a couple of things, right? So, the first thing is when you ask what are the risks, I guess all of the risks of being a startup founder, right? All of the risks of being an entrepreneur, which you probably can speak to better than I can, with the additional risk of your actual status in the US connected to this endeavor, right? So, that last sliver is the thing that I can speak about the most intelligently, but just to slightly address the first point, and maybe Sid, you can speak on this as well. Do you have to pay back a loan to an investor, to a bank? I mean, a significant part of this depends on how you structure the business, right? There are structures of businesses that, in some sense, protect the owners and put the liability on the business, right? And a corporation versus an LLC, some of these decisions that you may want to make at the time that you form your company. But probably, yes, the business is going to be liable to pay back things. Will you personally be liable? I'm not actually an expert on this. Maybe Sid will have more information. But generally, you're taking those risks. What if the business doesn't work? What are you going to owe? It's from an immigration perspective. If we're talking about the H-1B especially, you're going to have been approved for H-1B status for a certain period of time. Let's say, for the sake of argument, you're approved through September 2026. In July of 2025, business shuts down. Well, from the final date of your actual employment, you enter a 60-day grace period. And this is standard with the H-1B that it's been in place, I think, since 2017. But you guys will have experienced that perhaps in your employment at third-party companies. So you enter that grace period and you have to take some action in that time, exactly the same way as if you were working at Amazon and you got laid off. There's not a unique or special or additional struggle or concern because you were the founder, right? Other than the fact that there's that whole, like I said, range of things that are risks because you're an owner founder. Does that answer the question?
Yeah. Now, the first part, as Raghavan said, the structure, I mean, limited liability company, by definition, you form an LLC so that your investor money that is put into an LLC, you're not personally be liable for that. Right. So it's advisable to have an LLC and structure like that that saves you a business's debts separate from your personal income. I think the bottom line here is that the loan and the debts are independent and they're applicable similarly to if you were a US citizen and start a company or if you are an H-1B or F-1 student. So those things do not change. I'll move on to the next one.
Just before you do, I do want to address, because somebody in the chat asked a question about this. So the question, sorry, is that the 60-day grace period page on the USCIS page is not archived. Maybe then it is archived, I'm not sure. But is it still a 60-day grace period? Yes, it is still a 60-day grace period. In order to update the details of something like the grace period, USCIS has to update their policy. They're an agency, and an agency, in order to update their policy, has to go through a certain process. They propose updates to the policy, they publish, and then there's a notice and comment period. Then they respond to those comments that come during that period, and they publish a final rule. So they go through this process to update not the actual legal laws about it. Sorry, that's an awkward way of saying that, but not the actual law, but the regulations that govern these details and the policies that they use. And the 60-day grace period is in the regulations. It hasn't been updated. And we've so far gotten no indication from the current administration that there's a desire to change that. So as of today, there is still that grace period. But that can change. It's just, as of today, it still exists.
Now, the next one, another interesting, and thanks, Manisha, for writing this down from a perspective of, really, really foundational. Some questions that we all keep in our heads. Sometimes we find it awkward to ask. So this forum is really there's no bad questions. We'll get that answered and we'll make sure that people get educated about it rather than just guessing. So, Raghavan, what happens if a founder steps down as CEO due to investor pressure? Can they still stay in the
I
US?
guess the answer is it depends. What was the visa? What were the details of the employment that they indicated to the government? So let's assume, for the sake of this discussion, that the person is in H-1B status. And when we filed the H-1B, we indicated, and this is true for all H-1Bs, your current H-1B, if you're in H-1B status, this is true for that. When you filed the H-1B, the company submitted to the Department of Labor some details about the employment. They said, here's the place that people are going to work, or person is going to work. Here's the salary the person is going to receive. And here's the job title that the person's going to have. And this is the government standard occupational classification, which we shorten to SOC. Here's the SOC that the person is going to work in. So let's say for, again, the sake of argument, it's a software engineer. And you say, I'm going to be principal software engineer and CEO. This is the job category of software engineer. I'm going to work in San Francisco. It's a wage level 2 position, and this is the salary. If those details change, it is entirely possible that a new H-1B petition is required. If the investor pressure results in you saying, I'm not going to be CEO, but I'm still software engineer, still getting paid at least what I indicated on the LCA, still doing broadly the same job duties, then it doesn't really necessarily impact the H. But if you're going to have to get paid less, or you're going to have to go down to part-time, or you're not going to do those same duties, then it impacts the H. It means that in order to be able to work under the new terms, you have to file a new LCA and an H-1B amendment. So probably the answer is yes, because I'm sure if you're in that scenario where they're asking you to step down, they're actually asking you to change substantively a lot of what you do. But that's, again, more Sid's area of expertise, perhaps, right? I'm not suggesting that you've had to go through this, but I mean, just dealing with investors and the pressures that they can give.
Yeah. Now, Rob, a similar question on that same line. Let's say I was, as an owner, I employed myself on H-1B and I took, let's say, 100K. And now, down season, revenue's down, and I feel like I can't pay myself the same salary. I want to go down to 80K. What would somebody in that situation,
Again, it depends on what we said in the LCA. So when LCA being the submission to the Department of Labor that provided those terms, you're required in H-1B status to pay an H-1B employee at least what they call the prevailing wage for a U.S. worker in a similar position. And the Department of Labor publishes their opinion on what these prevailing wages are in different locations. You're not actually obligated to follow that, right? There is an Office of Foreign Labor Certification that most people use for these prevailing wages, but it's not the only way you could do it. You could do a wage survey, like you could actually commission a wage survey. Some large companies do this. I would guess a company like Amazon or Microsoft probably does wage surveys, because usually those will result in lower numbers than the Department of Labor ones. But if you're a startup, you're probably just using the Department of Labor info. So you have to put at least that number. Let's say it says 100,000 a year, as you mentioned. If that's what the wage level was, then you had to have at least indicated that's what your actual wage was. Right. But you might have chosen to indicate a higher wage. Many people do. Prevailing wage rate is 100,000, but this job pays 120. Now, you are tied to what you said, not what the prevailing wage is. You said on the LCA 120,000. If you're going to get paid less, you have to do a change.
We have to default at least.
Yeah, you have to file an amendment. You have to make a change, which kind of counsels, if you don't have to, don't say more than the lower prevailing wage. There's nothing wrong with saying on the LCA, gonna get paid at least 100,000, and then actually paying yourself 150,000. Oh, that's one item. Probably the most common solution I see to that dynamic is not working full time. If you're saying, look, we're running out of runway, where we have a burn rate that's going to mean we lose money in 6 months, but I need to work for another 12 months, then the most common path usually that I'm seeing, unless you can actually raise more revenue or investment, is file an H-1B amendment and knock your work down to part-time. It's a completely reasonable, viable solution. The government has no issue with part-time work, but, and this is a reasonably big but, make sure you're actually doing it. Make sure you're keeping good records, because we haven't seen really, in our clients at least, a significant follow-up and check and pushback, but I can envision that would be the case. And we know that immigration is a big point for this administration, and they've got a bigger budget for certain things in immigration. I could easily foresee, and I'm sure it happens, just not to our clients because we tell them not to do it, but I can easily foresee somebody saying, I'm working part-time, but then not keeping track of their hours, not keeping track of how they're supposed to get paid, just getting a pay stub that is the mathematical calculation of what they listed. And then on a site visit, if an officer asks, well, prove to me that you're working part-time, they've got no evidence to prove it. And, an officer probably is going to say, well, I'm assuming you're working full-time unless you can prove to me you're not. So use a time tracking app, submit timesheets, have the contemporaneous records to show you're doing what you're supposed to. And then there's nothing wrong with part-time employment. So yeah, so that probably addresses that.
Well, just do one more thing to clarify on this. Giving yourself a raise, let's say 100K was my LCA now, I want to pay myself 140. Is that okay?
It's totally fine. If you get paid more than you indicate, that's not an issue, especially when we're talking about a startup. There is, in theory, a possible issue with an individual in H-1B status being paid more than we indicated. And that is, maybe that is an indication that the company's actual salary for a person in that position is different than what we said it was, right? Because when you do, and this is uncommon in terms of the, I think, depth that most people look into this. But technically, when you submit an LCA and you look up the prevailing wage in that area, that is one part of the prevailing wage calculation. The second part is, does the company currently employ anybody else in the same or similar position? And what do they actually pay those people? You couldn't say, I'm hiring this person as a software engineer. The prevailing wage in San Francisco is 130,000. Pay them 130,000, but every other software engineer you have who works in the same department doing the same kind of job is paid 180,000. You're doing the wrong calculation. You're supposed to pay them 180,000. It's harder for the government to know because they don't know all your payroll. But if they ever did a site visit and a check and a look, then your actual wage calculation was done incorrectly. So maybe if you're being paid 180, it's indicative of the fact that your actual wage is higher. And so that's a more nuanced possibility. Most likely, it's not going to be a big deal. And it's very common for people to increase their salary. And the other thing is, especially given the context of what we're talking about, you're a founder, right? Yeah. Most likely you don't want to pay yourself more, but also if you're going to want to make more money, make that more money by taking the dividends from the company, by your income from the profit, not the salary. You're going to be taxed differently. I'm not an expert on tax, but you're going to be taxed differently. It's going to have probably a bigger benefit to you to that be the source of the income is the fact that you've got the ownership equity.
Yep. But I think I've done that to myself. I gave myself a raise, which was nice. But I think the bottom line is that you don't have to do an H-1B and USCIS paperwork just so that you can pay yourself 20K extra or you're taking more money out of your own company.
Yeah.
It's not that your H-1B says 100K, now your 120K is somehow a violation of your contract. But paying yourself less, as Raghavan says, what you indicate on your LCA, if you say that's the minimum wage for L3, so I think the best idea is to go lower number of hours while respecting the hourly wage, which is brilliant. Folks, we have a lot of questions on chat. Let me do this. Let me take a couple of questions which I know that some people will not ask, but they are pretty common about nonprofit and a few other things. Raghavan, this one is pretty common. What are the benefits of having a co-founder or investor with a green card of citizenship? And at what stage should a founder consider switching to an O1 visa or EB1, EB2, NIW? What are the benefits? How early should a founder plan their move?
So the biggest benefit of having a co-founder from an immigration perspective is you have the ability to have the co-founder be the signer on all the details, the co-founder to, at least according to the papers trail, at least according to the things that are written and detailed, be the one who is directing and leading those details. That's probably less of a concern today. When we were talking about 2024, 2023, prior to this January 17th policy change, then we were significantly concerned with being able to show the company controls the employee's work. And co-founder is really beneficial because you can have the co-founder be the person who is technically in charge, who has control over the company. You report to the board that the co-founder has more control over. But now in the current paradigm, that is not a question. It is irrelevant, right? I think people sometimes are still confused. I mean, we're only 6 months into this, but I've talked to people multiple times who say, hey, I'm worried about the right to control. Do I need to set up a board? Do I have to do this? I think there may be some conflicting information out there. No, you don't have to do any of those things. You do not require a board. You do not require somebody controlling your work in order to file an H-1B, have it approved, and work on your company. But the other benefit that is still there for the co-founder is, what about before you file the H? Because I see some questions from people as well about this. What's the right timing you mentioned, and what can I do before I get there? Technically, and this was a question I saw, you can't build, develop, launch an app, publish it, even if you're not monetizing it. You can't do that unless you have work authorization, right? What's the likelihood that you're going to be caught? What's the risk of the government being aware? Very low, because you're not monetizing it. And, they're not out there trolling all of the app stores trying to figure out who published these things, right? So your chances of it becoming an issue are low. But if they knew, it is an issue. Don't think, because I'm not taking money, I'm not doing anything wrong, right? The question that the government cares about is not, are you being paid? Well, It is when we come to like the LCA and meeting the H-1B requirements there. But I mean, the fundamental question the government cares about is not, are you being paid? It's, are you doing work? And they define doing work the way they define it, right? Like they would believe, they would consider product development and launching of an app work. You're doing work for that product. So you need work authorization to do it. So if you're in H-1B status and you're doing it without authorization for that specific work, you're technically working without authorization, because before you publish, no one's ever going to know. If you're sitting literally after this call, if you get off this call and start working on some app that you're just internally developing, no one's ever going to realize, no one's ever going to know, and it's not going to come up as an issue. But if you then publish it, now suddenly that trail becomes clear. So that's the other benefit of the co-founder is, hey, look, you both kind of throwing back and forth these ideas, and the co-founder can be the publisher. The co-founder can be the kind of primary operator of those things before you get the work authorization.
I'll add one more thing to it. So I had a co-founder, and when I incorporated my C corp, most people who have not done it, you don't need an official CEO title. You don't need any title. The only requirements are a president and a secretary. That is required by Delaware. And I had my co-founder, who was a Canadian person, not even a citizen, not even in the US, be the president and secretary there. And I was a majority shareholder. So I was an investor to this company, right? So I was enjoying this app being built and, making sure that I do all the investor things that I need to do, which is market research, right? Just understanding the landscape and making sure my money makes money. And then after my H-1B, I finally changed my title on LinkedIn. Until then, I didn't have anything on LinkedIn indicating that I'm doing any work or, product development as such. All right. I'll take the last one from for our script and then move on to the chat. So this one is, how viable is the IEP, the International Entrepreneur Parole in 2025, as a comeback option for H-1B holders whose PR wasn't filed or who are nearing their max out period?
Sure. So just to set the context of this, I think the reason for the question is to suggest you have 6 years maximum of physical presence in the United States in H-1B status, right? That's an overall maximum. After you work through that, then in order to get another 6 years, you have to leave the US for at least a year and go back through the lottery. Right. The exception to that is if you have I-140 approved, and the I-140 is the employment-based green card petition first step, let's say, right? Perhaps second step if there's a Department of Labor step. If you have an I-140 approved and your priority date, the date you filed or the date you filed the perm, is not yet current, meaning you cannot yet apply for a green card based on that timeline, then you can extend your H-1B beyond those 6 years. So that's the most common way. So if you are somebody who hasn't done the I-140, i.e. PR who wasn't filed, or you're nearing your max out period, then you do have to figure out a solution, right? Is the IEP a solution? Yes. Is it viable? I don't really think so. I was trying to do some research on this. It looks like in the, 5-6 years that it's been around, there have been a total of something like 26 of them approved, or something ludicrously low. If you think about that in the context, there's probably 26 H-1Bs approved today, right? At least, right? In comparison, in 5 years, they've approved so few. And so few apply, right? It's not like hundreds of thousands are applying. So few apply because the requirements are difficult and the gathering of evidence is complicated. Just at a high level, you have to show that you've received investment from a qualified investor. And a qualified investor is somebody in the US who has invested in other companies, and those other investments have created at least 5 sustainable jobs over a certain period of time. So you have to, in your application, provide evidence of some other company's job creation based on one of your investors' investments. That has been the roadblock that we have met every time we've tried to really push through working on this. I got investment from an investor. It was $400,000. They are a qualified investor, but how are you going to prove that the other companies they've invested in have jobs unless those other companies give you the evidence? And who's going to say, sure, I'll share 5 W-2s from my employees to some random other guy who's filing an immigration thing, right? It's just always been a roadblock for the cases I've tried to work on. So I feel like it's not a real viable solution. It is a solution. It works. People get it, right? 26 people, but I don't think it's reasonable. I think it's much more reasonable to try and work on an O1 or something like that than.
Sure. Very, very helpful. Okay, now, folks, I am gonna go to Slido first, just because we did ask people to submit questions there, and I want to respect that, those who did. I want to give you a link here as well. But let me share my screen actually. You could, everybody here can go, put the link in the chat and put your question there and upvote the ones in real time as if you want it to be answered. But this is sorted by basically single votes. So the first one, H1B founder employed by own C Corp as H1 employee, H1 holder goes to India, then stamping on return back to US. What are the risks other than
I guess the one that's slightly bigger is every time you enter the US, what the officer is trying to confirm is you're actually doing what you say you're doing, right? So if you enter the US, show an H-1B visa stamp, and you have an approval notice and you're working for Google, then, well, they know Google exists. They know Google employs people. So all they're going to try and check is, well, are you really working there? Some officers might not even investigate further. They might just believe it. But sometimes they'll try and get some confirmation of work authorization, recent pay stubs, something like that. When it's a company they've never heard of, then they might be more alerted to it, right? Well, I don't even know that company exists, never mind that you're actually working there. So there's a greater chance that you might be asked to prove that you're really working at this company. So still, definitely you should have pay stubs, but maybe you should carry with you some information about the company, right? But other than that, you're authorized to do that work. You're legally allowed to. So you're not encountering any other categories of risk. It's just because, a startup, a smaller business, perhaps does not have the same kind of recognition for an officer. They might be more likely to ask you questions to confirm.
timeline wise? How long should I run a company before safely starting H1B application for myself? Actually, I want to ask you, Raghavan, just one thing I'll add is, okay, what is there a minimum? I start a company tomorrow, I get some funding, 50K in the company. I got a business plan together. Does you see that the company was founded 15 days ago?
Doesn't matter.
Doesn't
Yeah.
matter.
No, and we filed cases where the person comes to us and they haven't founded the company yet. And so we're working with them. I mean, I don't do the company formation. Maybe I'll refer to a different attorney. Maybe they're going to do it themselves online. They already have an attorney that's working on it. But yeah, you could form the company on July 1st and file the H-1B on July 10th, right? You couldn't file the H-1B on July 2nd because practically you cannot submit an LCA and wait the 5 business days for it to be certified before the company exists and has an FEIN, right? So there's going to be some delay. But yeah, if you form the company, you put the money in the bank, you have the business plan, there's no legal requirement of a runway. But this question ties into a couple of other questions I'm seeing in this chat. So, how long should I run a company before safely starting an H-1B application for myself? I think I mentioned this the last call we had, but when I read that question, the first thing I think is, if you don't believe, then the government's never going to believe. So if you're saying, I'm running this company, how are you going to convince an officer you're not working without authorization? So your first thought process is you're not running the company until you have the work authorization to run the company, right? Because again, if you don't believe what you're saying, how are they going to believe what you're saying? So how long should I have founded the company? How long should the company exist? What things does the company need before I can file? I think this is the way you should be thinking about that. And what does the company need? The company needs to exist. It needs an FEIN. It needs to either have some money in the bank or some way to be able to show that it's going to generate money. One of the questions was, what if I've got no money and I've just got revenue generation? That's fine. But keep in mind that you are trying to convince an officer who may be skeptical that there is legitimate work available. And so they're going to be more likely to believe you if they see the money already in the bank than if you're providing potential contracts or providing a business plan that shows future revenue, because anybody can make up those numbers. But they could believe you, right? If you have a reasonable, comprehensive plan that sounds possible and you have good data or some evidence to back it up, then yeah, you don't need the money in the bank already, but you need to have some way to show that you're going to get it. And you got to have something to show what you're going to do, right? So that's where those business plan details come in. Can I work only part-time on that? Yes. You can be in the US only on a part-time job, right? You could say the only H-1B I have is to work 10 hours a week at this startup that I founded a month ago. That's possible. It's something that people do. Your question is, at least in the current paradigm, and I don't know whether this is going to shift, but USCIS in adjudicating an H-1B is not yet asking the question, but how are you going to live? USCIS is asking the question, does this meet the requirements of the H-1B and can I approve it? The people that have always asked the question, continue to ask the question, how are you going to live, are Department of State, right? When you go to a visa interview, if they see you have one job living in San Francisco, which is expensive, working 10 hours a week, making $60 an hour. So you're telling me you're going to live in San Francisco at $600 a week, right? And maybe after tax, it's going to be much less than that. They might say, I don't believe you. I'm not sure. I need more evidence, because they don't want to approve a visa, and CBP doesn't want to let somebody in when they know they're going to be working without authorization. So if you only have one job and you are only part-time, you should still think about how is it that you're going to be able to support yourself during this time? And that's a question that you've got to answer, not usually to USCIS, but probably to CBP or Department of State. And the last point on this, because there was some question about it, I just wanted to remember. Yeah, okay, so can you be the only person? Yes, you can be the 100% owner and only founder.
Yes.
And sorry, this is partially related, but I saw it and I thought it was a good question. So I'm going to just read it out. Hey, the H-1B is a specialty occupation, but being a founder, you'll wear many hats, right? It needs to be filed with a particular SOC, and that's got to be 51%. Is this scrutinized in terms of actual day-to-day responsibilities? Are they going to move dramatically over time, given the nature of the beast? As those responsibilities move over time? Yes, that is scrutinized.
Meeting.
Yes, that is important. But no, it does matter. It is going to be scrutinized. They do care, but it is explicitly countenanced, right? They specifically thought about, had questions about, answered those questions when they were developing this policy. What about the fact that you're a founder and you've got other stuff to do? And the government's position, right? Sometimes these things don't get into, sorry, I understand I'm not finishing a sentence here. So let me do this slight tangent and I'll go back and finish my sentence. But sometimes the actual kind of government policy doesn't completely get into the regulation, because the regulation has to be a very short sentence or paragraph. But the reason they have the notice and comment period, they publish the proposed rule and then the final rule, is because they go through and they address these questions and comments that people have. And people ask the question, what about the fact that I have to do other things? And the government then responds, yeah, we understand you're going to have to do other things. We think the fact that we're making this requirement allows you to spend a minority of your time doing the other things, and that's something that we're not going to be concerned about. And effectively, that is what they've said in their comments and response, right? So they know and they expect you will spend a minority of your time doing financial planning and meeting with an investor and whatever else you need to do to run the business. But they care that a majority of your time is on the actual occupation you listed on the LCA, and that's really what you're doing. So when you file an H-1B petition as especially the 100% owner-founder, you should almost definitely include a job description with percentages and really make it clear 51+% of my time is on this specialty occupation, and tell them the other 49 minus percent of the time. They don't have a problem with it. But make sure that if the 51% changes, if now I'm not doing software development so much, I'm doing, I don't know, data analytics, or I'm doing marketing as a majority of my time, you could have a problem, because you might not be qualified to do those things. I mean, you might be in real world terms qualified, but you might not be H-1B qualified, right? As in have a degree in a related field. So it should be the primary focus of your work to do the specialty occupation.
If it helps, Roshan, just I'll tell you, my entity hired me as a principal engineer. I think just related questions. Some people, we've talked about in the past sessions about titles. Raghavan has mentioned about how much it matters. And I've always, the answer is, even when I was a principal engineer, if I'm doing meetings, talking to people, I was still a founder. I was founder of the company. So I would introduce myself as a founder. And I was doing engineering, and that's what I have to do most of the time. But that didn't stop me from taking meetings. So, I mean, this is not I'm not an attorney. My answer to
Yeah.
this, don't get into minutia of, oh, I do 10% of data. If I do 5% of Excel and 10% of database, do I have to be data engineer or software engineer, or do I need to now be a sales guy? Right? You're invested anyways to the company. And now you're authorized to work for the company as a specialty of occupation guy. Definitely do your work, whatever your specialty is, but you're also an investor. So you should better make sure that your investment makes money and you'll
Yeah.
do what needs to be done.
Yeah. And I am a lawyer, and I'm saying if you spend 51% plus of your time doing that specialty occupation, you are allowed to spend 40% of your time
That's just
messing
slap.
around in QuickBooks trying to make the business work, right? Like that's totally reasonable. But the other thing about the titles to say is before you do anything, right? Before you get the work authorization, don't use an active title for yourself at the company. Right. I think we've mentioned that before.
Mhm.
If you form the company, which you can, right? We didn't say this explicitly in this call because we talked about it before, but you could be sitting here in H-1B status and tomorrow incorporate an entity, right? You're not. That is not working for a company. That is owning a company. And owning
Right.
is different from working. So you can form the company. You can be a founder, but you shouldn't then say on LinkedIn, hey, I'm whatever I am, and then I'm also CEO of this new company. You're
Right.
not CEO. You're not allowed to do the active work. You're co-founder, you're founder, fine. But then when you file the H-1B, I guess I don't know how everybody does it, right? But I know how we do it. We always disclose to the government the things that are going to be important, right? We're not trying to hide the details. We're trying to
Mhm.
argue the details are legal, right? So we will include this is the principal software engineer, and then that's going to be the title on the LCA. That's going to be the title that we indicate in the filing. But in the support letter, in the job description, we will explicitly say this is the principal software engineer, but he's going to externally use the title of CEO because that's what's expected of a startup of this size, right? When he talks with investors, they expect to interact with somebody with that kind of title because your job title doesn't imply, well, it implies, but it doesn't require you to do certain duties, right? Your job
Right.
duties are what matters. Your job title shouldn't matter, but kind of does because it persuades people. So that's why we're trying to explicitly say certain things and let the government know, hey, I'm principal software engineer. I'm going to use the title of CEO. Then when you actually go out there and work, principally engineer software and minority of the time, do the founder work that you need to do.
Yeah. You know, you can define founder title in the way you want. I don't know how you define one, but you
Yeah.
can be the founder. Okay, this one's not a question. This one's, so you can see my mouse is, I talked to Michael Sorati back in 2022, and he was helpful. Thanks to him and his firm, and Raghavan is here. And the call was a starting point for me to build the guts for the journey. Amazing. Nice.
I think if you ever interact with Michael, he is a very high energy and he loves this, right? Like he loves working with startups. He loves doing this stuff. I'm sure anybody who's talked to him would say the same. So yeah, thank you.
My H-1B petition, non-premium, is with USCIS. I have a receipt number. Can I travel outside USA now? While coming back to USA, do I need an approval?
Sure. So this isn't, I guess, directly on the topic of founders, but this is probably a scenario that many people that are transitioning to be a founder of their own company will find themselves in. Because legally, when you are in H-1B status, maintaining that status, let's say you've got an approval through 2020 to work at Microsoft, and now you've founded your company and you want to either do current employment or just completely transfer your employment to your company. Because you're in status, you can file that petition and start working upon receipt. That means, especially for a startup, you can save the 2805, right? I don't need to pay premium processing because I'm allowed to start working as soon as I file. So that's good enough for me. And so it may be the case that you did that, you started working, now you're in a position to travel. I guess I can't say in a blanket sense, can I travel? But as long as you have the following things, you should be able to travel, right? As long as you have an approval notice for your either prior or if it's concurrent employment, principal employment that is valid through whenever you're traveling. So let's say it's valid through 2027. And you have a visa stamp that is valid through 2027 and you have the receipt notice for the change of employer or the concurrent employment, then when you travel and re-enter, you can present those three items, say to the officer, hey, here's the approval notice and visa stamp, but I actually changed my employer to this. Here's the receipt notice. They may ask you, do you have any proof that you're working at that company? Do you have any pay stubs? Those things that I mentioned earlier, but you are authorized to be admitted, right? Of course, they might not admit you for other reasons. Maybe you committed some crime or something. So I can't say you'll definitely come back in. But I mean, those things are sufficient to be able to enter. So yes, you can
Right.
travel just with a receipt as long as the approval period is still valid, right? Let's say you filed the change of employer and your prior approval expired June 2025 and you've still got the receipt notice, but the new one hasn't been approved. Then you can't be readmitted because you don't have an approval notice that covers the time period you're trying to enter for. You're coming in July 2025 saying, here's my old approval and my new receipt, but the only approval has already expired. They're not going to let you in until you have an approval notice that is valid on the day you're trying to enter. right?
Clarify on this one again. So if I had an approval previously, which expired in March, also filed a non-premium H-1B in April, and I have a
Hmm.
receipt, and
Well,
I,
you wouldn't have filed in April. If it expired in March, you should have filed, let's say, in February. But yes,
let's say in
yeah,
February, and I
yeah.
have a receipt for it, and it's still pending, and
Hmm.
I leave and come back in July.
Hmm.
Are you that's a problem?
Yeah,
Just
they won't let you in. You can't because you are currently trying to enter the U.S. Well, number one, you probably don't have a visa stamp that's valid, but sometimes they do issue the visa stamps just for the full time period they could, not the approval notice. So you might have a visa stamp. So you present a valid visa stamp, but you can't present an approval notice that covers the day you're trying to enter. So they won't admit you. They'll say to
got.
you, you need this H-1B approved before you come. More
It's like
importantly,
coming to a country with a fresh H-1B, which is not even approved. My previous one is expired, so I don't have an.
exactly. It's almost like you just filed and it hasn't been approved yet. But more importantly, because this is maybe a nuance that people don't pay attention to sometimes, when you have a receipt notice and you're filing an extension, right? When you're filing for an extension, which is what you would be doing here, right? If your status expired in March and you filed in February, in addition to changing employers, you are filing for an extension of the time period. People understand and hear and kind of just think about the fact that the government allows you to keep working while the extension is pending. Right. But that's only true if it's an extension to work at the same employer. If you're approved to work at Google until March 2025, and in February you file an extension of stay, then you can work in April, May, June, July, August for Google while that case is pending. But if you filed a change of employer, then you got to stop working the day your approval notice ends, right? So when you file a change of employer with an extension, like a change to your own company with an extension, if you're requesting beyond the approval period of your current H, then you want a premium process if you're getting close to the end of that approval notice because you're not going to be able to keep working after that approval expires. You might not realize it and keep working, and technically you're working without authorization at that point, right? So don't do that. And to answer the direct question, you got to have an approval before you can.
Cool. Folks, if you have a follow-up, you can put in the chat. I'll pick it up. I'm going to move on to a different question, but this sounds like this was there's a bit of a meat in here. So I'll give you a few seconds on the chat if you have a follow-up to this question, but no new question, please. All right. Post January 17th, should we still need to show employer-employee relationship? I guess how do we
No.
do that when one person owns 100% company? So this is
January 17th to 2025, you do not need to show employer-employee relationship.
you don't need to be fired from your.
I mean, the previous paradigm, we would always say the company controls your work. Your existence as an owner is separate from your existence as an employee, and the existence as an employee can be terminated by the company. That must be true in order for you to be able to get the H-1B. That was the old paradigm. In
Right.
the current paradigm, they've specifically said right to control is not an issue. It doesn't matter if you own everything, there's nobody else involved. It just matters, are you really going to do the work you say you're going to do? Right? Are you going to do software engineering work a majority of your time?
Rob, what's question on that? Have you, and is this in your experience playing with a one-person entity? Is there one person?
We filed a couple of them where it's just they're the only person in the business. And you know, when that happens, there's a practical question as well, which is, well, who's signing the stuff for the company? And
Right.
I'm a conservative person. And
Yeah.
so when somebody else exists, I mean, in terms of my advice to clients, I don't mean in terms of my political persuasion. Not that there's anything wrong with that. But I'm a conservative person. And so when we file cases, if somebody else could be the signer, I'm always asking the other person to be the signer. But we've had
Okay.
a couple of cases now since the new paradigm where they're like, well, there's nobody else who can sign. I'm not putting a board in place. I'm the only person. And we said, okay, you be the signer. And had no issue with it. So
Right. So,
they're signing as founder,
like,
filed the
say
case.
the
Sign.
Raghavan, the founder, Raghavan, the employee, and the
Yeah.
separate.
Raghavan is signing the I-9 as founder for employment of Raghavan as principal software engineer.
So, for those who find this like weird in business as well, if you have a C corp, it's a living entity. It files its own taxes. So,
Yeah, yeah.
it's the entity
Thanks to
that
Citizens United is a person, right? So
the person. So you can represent a C corp and have a very different entity and hire yourself and all that. Okay. I did Delaware Corp before Jan 17th, 2025. My friend is CEO, owns 10%. I own 90. At the time, I wasn't working on my firm. Now I applied for H-1B through my firm. Okay. This is,
yeah, the question is a bit cut off, but it's a completely reasonable scenario. If you own 10% at the time, you just owned. Your friend is the CEO. Oh, sorry. If you own 90% at the time, your friend is the CEO owning 10%. Completely reasonable. Your friend can file the petition. You could file the petition now, right? When I say you, I mean be the signer. The thing filing the petition is the company, right? The company is still filing the petition. I just mean you can be the person to sign.
Hey, Srinesh, I feel like your questions are a little, I think they got voted up and down, so they are in different order. If you want to paste your question again in the chat, I'll take it again. If I qualify for O1A and get it, can I use the same criteria and evidences to apply for EB1A after a few months of O1A approval? Hmm.
Yes. Will you be approved? I don't know, because the standard that the government uses to adjudicate the EB1 is higher, is more difficult, more strict than the standard they use to adjudicate the O1A. But the elements, the criteria are basically the same. Not quite. The EB1A has a few extra criteria because not to get too technical, but the O1 is technically available both as an O1A for people in business and those kind of things, as an O1B for people in arts, and they have slightly different criteria, but the EB1A is a single extraordinary ability category. So they try and combine those two O1 types. So the criteria is slightly different. But yeah, you could literally fill out the different form and repackage your O1 to submit the EB1A and you could be approved. But I don't know how strong your O1 is. If you're just meeting the criteria for the O1 and just about got approved, you probably won't get approved on the EB1. But if you filed an O1, you're like, look, I was great. I had 6 of the 8 criteria. I've got lots of good evidence. You don't need anything more, potentially. But of course, we got to look at the substance of the case, right?
Okay. So we're going to move on to chat questions now, but quickly, we'll take these two. Raghavan, for this one, it's been about half a year for the new rule. How are petition success rates looking? Any lessons learned or pitfall uncovered?
Yeah. Good question. It's hard because I have such a narrow view, right? I probably have a wider view than you guys on this call because I see lots of cases in comparison to you. But in comparison to all the cases filed with the government, I see a small number, right? So our experience has been positive, right? We were unsure because if you kind of piece together the timeline, literally on the last day possible, the Biden administration updated this policy, right? They did it January 17th and Trump took office January 20th and the 18th and 19th were Saturday and Sunday, right? So they did this at the last hour and it was unclear to us, will the Trump administration immediately try and reverse the policy, adhere to the policy, what will happen? But in these 6 months, like I said, we filed cases with you're 100% owner and there's nobody else in the company, with 80% owners, with I have $40,000 in the bank and a good business plan. And these cases are all being approved so far, right? So we have not had any cases not be approved, partially because we're kind of telling people, make sure you have all these details in place, right? But yeah, that's been positive. But I'm sure there are cases that aren't approved, and I'm sure we will have a case in the future that's not approved, right? What's the thing you see by personal injury attorneys all the time, right? Like past results do not guarantee future success or something like that, right? I can't say that we won't ever have one of these denied, and I'm sure there will be a time where it will be because of something we did, because everyone's human, right? But so far we've had really positive results, and I think that the rates have not significantly decreased. Yeah, hopefully that addresses it. In terms of the second part that you were saying about the green cards, a company that you own such a significant percentage in cannot, under the normal process, petition for a green card for you, right? Like by normal process, I mean probably the process that most people on this call have followed at some point or will follow at some point is a company filing a labor certification and an EB2 or EB3 40. If you own a significant percentage of the company, it is almost definitely not going to work for the perm. We filed perms that have been successful where a person owned up to about 20%. It's difficult because the Department of Labor is the problem. The Department of Labor wants you to actually attempt to hire an American for that role. And so you have to do recruitment. And they will almost definitely not believe you that you did an unbiased recruitment if you own 60% of the company. So that is not going to work. But the process, the pathway that people follow when they're doing this startup founder journey is going to be similar to what Sid did, right? You're going to do an EB1, you're going to file for extraordinary ability, or you're going to file a national interest waiver. In both of those scenarios, the company doesn't need to petition. You're self-petitioning. So in that sense, the question in some sense doesn't make sense, right? Like the question's phrased correctly. I read it wrongly. Yes, they have obtained green card successfully. I guess via their own companies, not really via. But yes, people are doing it, and they're doing it through the EB1 most likely. The EB2's big drawback, the NIW's big drawback, is it is EB. It is still, if you were born in India, a backlog of 12 plus years. So you don't accelerate anything by doing the NIW. There's no value if you were born in India of doing an NIW unless your priority date is close to being current, right? Or you don't have an I-140 yet, and you're starting your journey before a third party company did the I-140. Then there's value because now you're doing the I-140 EB2 NIW because you're trying to extend your H beyond 6 years, right? That's a different thing. And of course, if you weren't born in India, if you're born in Pakistan or the UK or South Africa or any of a myriad other countries, right? Yeah, Nepal. Exactly. Except for India and China and a few others, the backlogs are minor. So yeah.
I would re-stress the point Raghavan said, that just to be sure here, because I speak to a lot of you, and most of you have EB2, been here 10 years, founding, and so the real solution for a green card would be to go to EB1.
And this last question by Dunmay is related, so I'm just going to address it. This was on the chat, not the slide, and that is perms are not transferable, right? Ever. The only scenario in which a perm is in some sense transferable is if there is a successor in interest to the company that filed the perm. When we talk about you transferring your green card process, we're only talking about you retaining priority dates, right? If you have a perm approved and an I-140 approved from Google, and then you leave to Microsoft has to file a new perm for you, right? Yep. They're not somehow taking over the perm. The only thing is that they get to use the same priority date. The I-140 is also not transferable. An I-140, well, assuming it was a perm-based I-140. Of course, if it's an EB1 self-petition, then it's transferable in the sense that as long as you're working in your field, it's still valid. But the only thing about an I-140 that gets transferred is the retention of the priority date. If you move after 7 years, right before your priority date becomes current to a different company, they don't get to just use the fact that you have the I-140. They start at day one. They do a new perm. They do a new I-140. They just keep the priority date. The only exception to that is if you've got perm, I-140, and 485 all filed, and the 485 is pending for 6 months. So you're that close to the end. Then you can port to the underlying job offer to a different employer without doing the perm and I-140 again. That's unlikely. That's uncommon for most people here. Probably, I guess. You could be in that scenario, in which case, fair enough.
Yeah, I think two things I'll say about priority date that I think it's key that I learned. So I had my EB2 priority date, and I could port that date to my EB1A filing. So when I got my EB1 approved, it was still getting backlog, which is still now in a big backlog. But if you have your EB2 from 2018, 2019, you can use that date for your EB1. So,
that's right. Is that priority dates for EB1, 2, and 3? You could use the earliest one. That is legitimate. There's some scenarios in which they don't transfer, and that's because if you get the I-140 approved and within 6 months the company that petitioned for you goes out of business or withdraws it, then you don't keep the priority date.
Okay, we'll go to chat. I think, Rob, in the interest of time, shall we just look at the chat, and we can pick up like things that you haven't answered. And folks, if you have any questions, feel free to type it now.
So I see the person who asked the question, hey, my H-1B title was lead quality engineer. Can I put CEO on LinkedIn for fundraising? Is it better to put LinkedIn or CEO or founder? It's a hard thing to be exact about, right? Because everything is a risk assessment. I think there's lower risk if you say founder. So it's easy for me to sit on the sideline, not being the person involved in fundraising, and say, just put founder. Like, I don't know how it impacts your fundraise. That's a question for Sid, right? Like, is it really impacting you from a fundraising capacity perspective to not be saying CEO? It feels to me from the outside like, why would that impact it that much, right? Call yourself a founder and move on. But if it really does impact you and you critically have to call yourself CEO, technically you could, because it's just a job title. The thing is, maybe somebody might see it. You're traveling back in, they're like, wait, it says CEO here, and I thought you were supposed to be lead quality engineer. And so you may need to answer the questions about it. Hey, look, that's a title I'm using because I work at this startup. I'm also the founder. My day-to-day job duties are actually those of a lead quality engineer, But as I've said, I think in previous calls, I say to this to people all the time, it's always better not to have an argument than to win an argument, right? So if you can just avoid having the argument by putting yourself as founder, you're in a better position than if you put yourself as CEO, they question it, you respond, and then you win. Sure, great, you won, but how much did it cost you to have the argument that you could have saved by just saying, call yourself founder?
Take on the business. Titles are kind of internal, right? in a way. For H-1B perspective, the LCA, you really have to respect the specialization, but saying title in a way, what is a senior engineer? Like I define it for my company, what a senior engineer is, right? It's really no law on that. Titles are internal. I've been in calls in my previous startup where my sales VP of sales introduced me as a director, and I wasn't because in the sales he wanted me to look, big and as if I owned a part of things, and so these things happen. I think H1B founder versus O1. What's your take on that?
Right. It's an interesting dynamic. So um, everything is going to be specific to the individual, right? So it's hard to answer the question specifically for Karuna, but to give you some of the thought processes, right? Maybe some of the pros and cons. The H-1B has one significant benefit that is dramatic in comparison to the O-1, and that is your spouse could work, right? If you have H-1B status and you have an I-140 approval, your spouse can apply for an EAD and work. If you're in O1 status, your spouse can never work unless they get their own one or their own H1B or something else. So often with people I talk to, they're working at a major company and about to start this company, but they have a spouse that is in H4 using the EAD. And so it's like, well, don't switch because that spouse is going to be screwed, right? The other benefit the H1B has is it's got dual intent, which means there's no point in time where you will be restricted in your ability to travel, regardless of your step on the green card journey, right? No matter what you file, no matter where the government is in adjudicating a green card, your H-1B means you can always be traveling as long as you have the H-1B visa stamp. The O-1 has quasi-dual intent, but I hate quasi-dual intent. I was just talking to a colleague about this today. It exists. It's a thing that people have said in policy manuals and Q&As. But what does it mean? Anything that isn't written in the regulations is something that a government officer could just decide not to do, right? So I hate the quasi-dual intent concept, but in the interest of fairness and other people's opinions, I have to say it does exist. There is some idea that you can still get the O1 visa stamp even if you have a green card application pending, and probably that's true. Me personally, I don't like advising it. But the O1 has some other benefits, right? Number one, if you're a founder on an H-1B, the new paradigm restricts your ability to get the approval to 18 months, right? So on an O, you could get the approval for 3 years still. So all right, that's a benefit because you have fewer filings you have to make, so you're reducing your cost. Another thing is with the one, you're defining your field, right? So maybe your field of expertise is in data analytics or artificial intelligence connected to something, I don't know, Internet of Things or refrigeration technology, I don't know, whatever it is. But when you've identified that field of expertise and you've got the O1 approved, you're able to work in a position related to your field. You could just do any of the work you want to do. With the H-1B, you're restricted to it being a specialty occupation. And the only specialty occupations you're qualified to do are the ones you have a bachelor's or higher degree in, or you have the equivalent of a bachelor's or higher degree in. So if you got a degree in mechanical engineering and you want to do your startup in fintech and your focus is going to be really on the finance side, you're going to struggle to get the H-1B approved. I mean, how can you be a financial analyst with a mechanical engineering degree? It can work. You can make it work. There's some complex arguments about things that you might try and make, but you're always navigating that. Whereas if you have a mechanical engineering degree, but you built a career in finance or finance related things, and you have an O1 approved to do financial and analytics stuff, then go ahead. Doesn't matter what your degree was. And finally, for the O1, there's no restriction or requirement about your salary. So if you're an early stage startup and every penny counts, H-1B is making the company pay you $140,000 a year maybe to meet the prevailing wage requirement. Whereas for the O1, there's no requirement. You can be paid, $1,000 a week if you wanted to, right? Or a month, as long as you're working. So those are the kind of the thought processes. There's probably more factors involved for individuals as well, but yeah, many people choose the O, many people choose the H. It kind of depends.
I think they're both premium processing, so they're both available if you need them. And I think the spouse thing is also interesting. So you all have to think about, if you need a H4. I think most people I speak to, at least in my experience in this group, have at least a partner or H4 dependencies.
I do want to address the one kind of follow up to my discussion about the I-140 transferability, because the question was, well, wait, but if I can't get the I-140 for my own company, then the spouse has to stop working, right? Wrong. If you already have the I-140 approved, even as long as it wasn't withdrawn or the company went out of business within 6 months of the approval, right? As long as it's been more than that 6 months, even if you leave that company, you have the approval notice for that prior I-140. It's still valid to use for the purposes of retaining your priority date, extending your H-1B beyond 6 years, and enabling your spouse to work. Right? Those three things, the old I-140 approval is still valid for. It isn't valid to be the basis for you to apply for the adjustment of status because
Right.
the job offer doesn't exist anymore.
This is very right. This is very interesting. So let's say I'm on a quota, this long line of 15 years. I got my EB2 approved today. So, and I switched my jobs. The thing to understand is my new company, I have my I-140 for this company is 6 months over, spouse is working and I'm renewing my H-1B. I do not have to redo my perm until I have to do an adjustment of status, right?
So you don't have to. I will say probably the practice usually is they do, right? Because it's not costing you. The
Right,
company is the one who's doing it. And well,
right.
if you're a startup, it costs you. But if you're not, it's not costing you. And I can tell from the market, and you guys are probably in a better position to feel this than I am, that people just would much rather have those things sorted out and updated with the current employment. So very often we do end up seeing people with multiple 40s approved over the course of time at different employers. But technically, you're right. I mean, up until the point where the priority date is current, it's not really required of you.
So I think a common myth that we have, like in the community at least, that if you switch a job on I-1, oh my God, the first thing you do is really refile the perm ASAP so that, oh my God, I have to get that back. And I'm saying that especially when you are on this giant EB2 wait list of 15 years, I think, because now if you're starting your own company, it doesn't take that thing away from you. Which is the point that you were stating that you have your
Yeah,
approval
exactly.
140 and until it becomes current, unless you want to apply for adjustment of status, you don't have to redo your form.
Yeah, you don't have to do it yet. So I don't fully understand the question here at the end about the H4 EAD. I think if I understand it correctly, the question is if I have the I-140 already approved and now I'm transferring my H-1B to my own company, can I, as soon as I transfer it to my own company, file the H-4 EAD? If that is the question, then the answer is yes, you can, because you already have a previous I-140 approved. You're now a founder, H1 founder, just do the H4 EAD. Frankly, do it at the same time. Unfortunately, there used to be a practice, a policy from the government that if you premium processed your H1B, then all dependent, and not just H1B, L1, O1, whatever it might be, all dependent applications that were included in the same filing, like an H4 or an O3 or something, will be adjudicated in the same premium processing timeline. First Trump administration, I think, it might have been Biden, but I think it was first Trump, stopped. They were like, yeah, we're not going to do that anymore. The dependent ones will take as long as they take. And then they got sued and they didn't adjudicate the lawsuit. They settled. They settled with the people in that lawsuit. And as part of that settlement agreement, they agreed that for a certain period of time, up until January of this year, they were going to adjudicate dependent applications that were filed alongside a premium processed case in the same timeline, right? Within a few weeks. Technically, that settlement agreement is expired. They are no longer bound by it, right? In practice, we're seeing them still adjudicate these cases mostly along that timeline if it's premium processed. But just so people are aware, if they're not, they don't have to. At any point in time, they could just stop doing it. They'll probably get sued again. Somebody else will probably try and do something. But right now, if they wanted to tomorrow, the service center could just decide, I've approved your H-1B. I'm not going to get to that H-4 EAD for 10 months. It's possible.
So in the interest of time, I don't want to take more. It's 9:20, 1 hour, 20 minutes. Folks, we'll do this again, but as you see, right, we get so many questions, so much interest. How does one reach out to you if they want to get in touch with Sorority Law and
For
you?
sure. I mean, sororitylaw.com is a website, which I'm sure as many people experience as kind of a business owner is in constant need of updates. So I can't promise that it's got all the latest things and details, but you can reach out to us through that. You can send me an email. It's my first initial last name at sororitylaw.com, Nagarajan. I think what we'll do is we'll share with Sid a link. I'll get it from my team and we'll share with him a link that you can put in maybe when you post this for people to kind of contact us if they want to.
Yeah.
And yeah, I mean, if you guys have questions, if you have follow-up things, then reach out. Hopefully we can help. I'd say we probably increasingly have filed a lot of these kinds of scenarios and cases. And we focused today on just the H1B founders and probably we focused not exclusively, but principally on people who are founding the company in this significant backlog. So they were born maybe in India and H1B is the solution for them. but the O1 is obviously a solution. And also, if you're from other countries, not India, but other countries, then there may be other solutions like the TN if you're Canadian, or the E if you're from countries we have a treaty with. So don't think that the H-1B is your only path here. It may be for some of you, but obviously we can assess that and
Right.
help people with those things as well.
And
Or
folks,
marry an American, and
yeah.
you'll be fine.
That's why, your every case is so specific. It's always interesting. It's like, it's like a giant flow chart, right? And you really will figure out where you stand. I have 10 coaching slots too, folks. So if anybody, for the business side, mentorship side, young me there. I have the link on the Substack too. I'm happy to chat it over in detail over now some of the incorporation and taxes and titles and investors and business ideas and all those front. I want to thank Manisha here. So she is now leading, she's the host here, helping us with the chat and questions that we did today. We'll be doing this a lot more regularly and like really trying to get this community more focused on the business side of things as well. And but Raghavan, thank you so much. This was amazing.
Sure. Yeah.
Yeah.
Thank you guys. Thanks for having me.
All right. Until next time, folks. Bye bye.